Thank you very much. Once again, I'm really happy to be here. The notion of doing this cross-cultural interchange is, I think, very exciting. There's no doubt in my mind that people who are, let's say, not as friendly to my clients as the rest of us have meetings like this all the time. As we learned this morning, there was collaboration early on between the New Democrats and people here getting together to try and figure out how they were going to at least end welfare as it once existed in a way that might have been more kinder and gentler for our clients. The place where I want to start the discussion is sometime in the 1960s in the United States with what Lyndon Johnson called the War on Poverty. And that terminology always struck me as somewhat off in a way. I mean, war on poverty, it didn't ever seem to work out quite that way. In the history since 1960s, I think Warren Buffett's remark that there is class warfare and my class is winning is much more apt than anything such as a war on poverty. But be that as it may, the architects had some very interesting ideas in mind when they started to think about confronting poverty in America in the 1960s. And it included local community-based organizations that were frequently called community action agencies, which were built around the ideas of community empowerment and having direct involvement of the poor in redirecting their lives and actually gaining some degree of influence on their futures, and support from lawyers who could help them assert their rights. And that vision was unfortunately never fully realized. Very quickly, it ran into opposition across the country from various quarters, including in California from then Governor Ronald Reagan, who actually saw the legal aid lawyers working on behalf of low-income farm workers as an enemy to people who were supporting his policies, who were perhaps the employers of those very same workers. And so you had this notion, going back at least that far, that lawyers aligned with the poor were not to be supported and to be resisted by those people who wanted to minimize the social costs associated with providing for the poor and the low-income working class. So that's happened in 1970s when Richard Nixon became president. He also gave some lip service to trying to start the Legal Services Corporation, which became the national funding agency to provide legal services in the United States. I was informed earlier that here in the UK, you have the benefit of, or at least until recently, have had the benefit of decades of the notion that the right to a lawyer in a civil proceeding is one that is considered fundamental and elemental to your systems of justice. In the United States, we've never really had that. We have a kind of split system where that right is recognized in criminal proceedings, but not in civil proceedings. So there is no right to a lawyer in the United States. If you are faced with eviction, if you are faced with the loss of your benefits upon which you depend to feed your family and your children, if you are losing your social health benefits, Medicaid if you will, or if you're losing your Social Security payments, there's no right to a lawyer in the United States. And that strikes, I know some people on this side of the Atlantic as relatively strange for that country with the Statue of Liberty in our harbor and bring me your poor and your homeless and we'll take care of them. But there's been a pretty strong resistance up until recently to have lawyers to be able to work closely with the poor to assert their rights in every venue where they might need them. The Legal Services Corporation that was funded and founded in the 1970s came with it certain restrictions that limited what lawyers could do who were funded through that corporation. And those were also designed primarily to try and channel the work of lawyers towards individual representation of what I'm going to call small issues. Like small in the sense that the preference was to fund lawyers to defend people in evictions, to help them in divorce proceedings, but not so much to help them when they needed to challenge the government itself or to take on class action litigation or things that might deal with getting at institutional reforms. That's the history back in the 1970s. In 1972, thereabouts, there became a big movement in the legal arena in the United States as to establishing the right to welfare benefits, which Vicki described earlier was an entitlement at the time, coming back to the 1960s. So if you qualified, you were entitled to the benefit no matter where you lived, as a property right. And a case went up to the Supreme Court of the United States that began in New York City over whether or not, if the government is taking away your benefits, do you have a right to some kind of what we would call due process? And thankfully, the Supreme Court said, yes, you do have a right to due process. You have a right to a hearing with an impartial fact finder where you can present witnesses, you can ask questions. But they did not go so far as to say you have a right to a lawyer. And subsequently, the Supreme Court decided that you do not need a lawyer by right to protect your due process interest in one of these hearings. So you have, on the one hand, a recognition in the Supreme Court decision Goldberg versus Kelly. The judges spoke quite eloquently of the brutal necessities of life, of having to actually depend upon the government benefits for your very existence, for your shelter, for your food, to support what you need for your family. And that in itself was a property interest for which the Constitution of the United States said you need to have due process before it can be taken away. But they did not go that extra step, which was one of the fundamental failures, I believe, of the United States judicial system in recognizing the balance at play between the individual and the government, because the government has all the resources that it wants to throw into any particular situation, whereas a low-income individual has virtually nothing. Over time, agencies such as the Legal Aid Society had developed expertise in bringing what's known in the United States as class action litigation in order to attack problems on a systemic level with how the government was operating its benefits programs. In the 1990s, Vicki mentioned the change with President Clinton in the welfare to work, when we actually brought into the full national agenda the welfare to work rules. Well, one of the corresponding changes in government at the time was a restriction on funding for legal services that actually cut back on even the limited amount of services that organizations could perform if they were receiving federal funding, so that they were not able to bring class action litigation, or they were not able to engage in the types of legislative activities that many law firms would do for their own clients. And the Legal Aid Society, where I work, actually turned down the federal government's money at that point because we did not want to have our independence compromised, and we ended up taking a significant financial hit for taking that position, but it enabled us, we believe, to perform our jobs in a way that was unencumbered by these restrictions that were being foisted upon lawyers, basically fueled by an agenda that wanted to prevent law reform on behalf of the poor. So there still exists in the United States a kind of two-tiered system of legal services for the poor, one of which is limited in what they can do in terms of relief because they're not allowed, for instance, to file class action litigation, and the other which receives which can provide only individual legal services. In 2001, there was a decision that said, if you are receiving restricted funding, but in order to represent your individual client, you have to challenge a welfare rule or law, you are allowed to do so. So that was some modest recognition that a lawyer representing a client could and should be able to challenge a government policy, but only on an individual basis. You were not enabled, if you had a Legal Services Corporation funded program, to actually take on, for instance, work that we've done recently at the Legal Aid Society, where we have challenged government policies that denied our clients millions and millions of dollars of benefits that they were entitled to. So, at that period of time in the 1990s, when welfare reform in America was beginning to become more of a popular theme for politicians on both sides and both political parties, Rudy Giuliani was elected mayor of New York City, and he very quickly looked at welfare as an issue that he could make some political statements on. Statements that were consistent with his political philosophy that basically resonate with what we heard earlier this morning, is that the poor are largely responsible for their own condition and that they should depend not on public programs but on private charity. And one of the things that he did was transform what had been known as income support centers to job centers, with the imaging thereof that you are now going to be creating offices which were going to help poor people find jobs, as if that had been the problem, as if the problem that our clients were facing was needing support in finding jobs. I pay a lot of respect to people who think deeply about the, I think we call it active labor? Active labor market policies. I think that they play a very important role, and earlier this morning I think the comment that there are some very good things happening here, was it the JSA? The JSA program, that could serve as a model if it was strict, if as long as you had a situation in which it wasn't linked to a very harsh system of sanctions that ended up having very unfortunate consequences. So the notion that Giuliani brought to New York was to use the rhetoric of job centers without really attacking, I don't believe, the fundamental problems that our clients had, which was that they were basically locked out of employment for a variety of reasons, for the most part. And in doing so, he very quickly began to ignore some of the legal protections that had been built into the system. And the Legal Aid Society and our allies brought a series of lawsuits to enjoin what we thought were some of the harshest aspects of what the mayor's immediate plans were. Those included a lawsuit called Davila versus Giuliani, in which we sought to assert one of the few rights that remained in New York for welfare recipients, which was if you were a single parent, you supposedly had a right to express your preference for the type of job or training program you would be placed in. And under the Giuliani administration, virtually nobody was allowed to express the choice to pursue education as opposed to relatively what we would call make-work programs, such as the Welfare Experience Program. That lawsuit was successful, and we basically established that they had totally ignored even the pretense of offering individuals a choice as to what employment path they might choose to better themselves and to work themselves out of poverty. Another lawsuit that we brought was Brown versus Giuliani, in which we attacked the administration's plans to lay off large numbers of workers within the human service agency itself. So the mayor came into New York City and saw that he could achieve two goals with one stroke by reducing the municipal labor force who were employed to help people at the job centers. He could save tax dollars right away. He also helped perhaps to weaken the unions that represented those workers. And knowing that there were going to be less workers to service the population, it was entirely predictable that benefits would be lost along the way, that people's entitlements would be trampled upon because there would be nobody there to essentially make sure that things got done right. And the rhetoric from the top was, we are much more concerned about lowering the welfare rolls than we are about seeing as to whether or not an individual is able to live and support their family. And that lawsuit was also successful because we were able to establish that they could no longer, there were certain time frames within the law that if you applied for a grant, they had to they had to make a decision. For instance, if you were pregnant, you were entitled to a small pregnancy allowance, $50 a month more in your benefits you could get. And that system had totally broken down by the 1990s. Another benefit, if you were being evicted, you might be able to get some assistance with your housing, with your shelter support. And that program was also not being administered within a time frame that was commensurate with what the law required, which was basically things should be done in order to meet a crisis, which is kind of common sense if you were designing a program. We brought a third lawsuit that was charged with the turnaways at the job centers themselves. So the mayor came in, what he did was he changed the names from income support centers to job centers, and then they literally began telling people welfare is over. There is no more welfare. We had clients who would go into the center for support, and they were told by workers at the direction of supervisors, tell the clients that welfare is over. Go back to your food pantry, go back to your church. This doesn't exist anymore. And we were successful in that lawsuit in getting an injunction also. But things my colleagues will talk about later on, all of this litigation is enormously time-consuming. Some of these lawsuits end up going on, in some cases we're able to achieve relatively quick victories and forestall government actions within 6 months, sometimes even quicker. But oftentimes, to get the full result, we might be litigating cases for years and years, during which times the relief that might be afforded under the lawsuit might be frustrated by bureaucracies that are not really 100% behind supporting what the court has ordered. So for instance, in the case of the Brown case, where the issue was people's access to timely decisions on their benefits, we found that in many areas of the city, the local centers were not complying at all with the requirements that they make decisions. And in fact, somebody would come in and ask for a special grant, and nobody would ever act on it. Nobody would tell them anything. And the ability of the Legal Aid Society and our allies over time to hold people accountable is part of the equation, I think, of looking at welfare reform. Because without that ability, agencies that have even a neutral attitude towards the poor, no less an agency which has an attitude that might be skewed somewhat against them, there's very little checks and balances in terms of how far they can go in abusing people's rights to the benefits they're entitled to. So one of our cases that we brought in 2010 involved a situation in which, in New York City, we have a very large system. As we talked about before, it's all computerized. And that was one of the things that was brought in by the Mayor Giuliani, and was brought in by his successor, Mayor Bloomberg. And they spit out about 10 million notices a year, or 10 million. I mean, it's a phenomenal amount of appointments that people are called in to come to the job center. I think, as Vicki pointed out earlier, there are cases in which people were being sanctioned because they missed an appointment at the job center, but they were actually reporting to another appointment at the agency, or missed an appointment for help with improving their resume when they actually had a job. So you have a lot of bureaucratic churning that goes on, and we found out that in one particular case, one of the few procedural rights that remained in the food stamp program, which is a second chance. So before they can sanction you, you're entitled to actually come to the agency, explain that I missed the appointment, but I'm willing to comply, and that was built into the food stamp federal law, had been totally ignored for 6 years or more by the state agency. So you have rights that were built into the statute that were being ignored by the state, that only but for the fact that somebody like the Legal Aid Society could come in and hold the agency accountable, they would have gotten away with it forever. In another instance, we found out that people with disabilities, I think this came out earlier this morning, the net result of the welfare to work shift is that you have a small, at least in the United States, is that you have a much smaller amount of people receiving benefits. There's a much higher concentration of people with disabilities, including those with psychiatric disabilities. And those people, in particular, have a lot of difficulty navigating a pretty bureaucratic system. And so we had a lawsuit in which we found that in a 6-month period, out of something like 20,000 clients, 15,000 of them had lost their benefits, either through a sanction or a case closing. These were people who with disabilities who were singled out. They were supposed to receive special assistance, but instead of receiving special assistance, they were just transferred to a different center and essentially provided with minimal supports. And as a result, their cases were either closed or sanctioned. If your case in the United States or New York, if your case is sanctioned, you lose a portion of your benefits. So if you're a family of 3 and the mother is sanctioned, she loses 1/3 of her benefits. If your case is closed, then you're going to lose all your benefits. Your case could be closed for something as simple as not sending back to the agency the lease that you have with your landlord. Even if you had sent that lease back a year ago, and you assume that the agency still had your lease, they could use that as an excuse to close your whole case. And people like that, this was happening every single day. I was looking at the graph that was shown earlier this morning about sanctions and the kind of fluctuation of the rate of sanctions. I don't know if you're here for that, but it looked like it had gone from like 2% to 8%, somewhere in that range. And in New York, for at least the past 15 years, the rate has been 20% or higher. So at any given time, 20% of the people in New York were facing sanctions. That means that they were having their budget either reduced or cut off entirely. And just recently, we've had a little bit of a change in New York City where the new mayor has looked at the issue from a different lens. It's not looking at these sanctions as a result of people who are trying to game the system and people who are not interested in complying with the program requirements. They're looking at it as more likely to reflect, I think, as the commission here reported earlier on, people who were caught up in the system, unable to navigate, perhaps didn't know what their responsibilities were, or simply had situation through a different lens. It's not based on change of law. It's not based on anything extraordinary that legal advocates are doing. It's simply another way of looking at the existing law and the purposes of public assistance, which is to support people when they need income. As you know, the job supports are important, but most basically, people have a need to pay their rent, to feed their families, and to carry on with the basic necessities of life. And so this admixture of income support and job requirements is being examined in a way that tries to, I think, best integrate the two policy areas to say, yes, we want to help people find employment. We want to help people, in the best case scenario, improve their lives through education. Everybody knows that the best way to get out of poverty is through advancing your education. I mean, study after study after study shows that. Up until now in the United States, by law and by policy, education had been frowned upon for people on public assistance. And the current administration, at least in New York City, is starting to look, and even in New York State for that matter a little bit, is beginning to look at what it means to help people get through two-year university programs, if you will, or four-year programs, so that you don't have that multi-generational poverty that was pointed to earlier this morning as something that is lending a persistence to second and third generations. If we can help this generation get in and get to college and actually lift themselves out of poverty, we're achieving the goals of the program if you look at it from the point of view of a true anti-poverty program and not simply a job training program. So I'm going to stop it there for now. We'll be happy to talk a little bit later about some of the other developments both in litigation and elsewhere, but I do think that there are plenty of opportunities. It's not that there aren't, I think as Ann said earlier, it's not that we don't have solutions to some of the problems that we've been discussing this morning. It's more, I think, a will to get there and the resources to do so.